Welcome to literary and jury charge practice. We'll start out with some literary material. Ready? Here we go. It's funny how things come full circle sometimes. Jordan Groves, a first-year reporter from Montgomery, Alabama, interned with several freelance reporters and officials in the central Alabama area during her time in school. She had the opportunity to sit in on depositions for a high-profile case that had been going on for several years, and then with a state official, ended up sitting in on the final day of trial in that same high-profile case. There were cameras and news reporters outside the courtroom. It was a zoo, Groves said. While most internship experiences probably aren't quite that exciting, for court reporting students getting their first taste of life as working reporters, all experiences can be just as memorable. Internships give students the opportunity to try on the profession and gain experience in the same track they intend to pursue in their careers. I know I wanted to freelance, so interning with freelance reporters was a good way to learn how to find the location of the job, said Groves. Walking into a big office building and having to find your way around can be very intimidating. Internships also give students a chance to learn from working reporters, and students should be sure to ask questions. I interned with 2 federal officials on several docket days and through a multi-day murder trial. One reporter was doing real time to her judge on a daily basis, and she took the time to walk me through every detail of setting it up, said Groves. In between dockets, she would take me back to her office and go through her file for the day and show me the notes she made to herself, all while real-timing flawlessly. I'm interested in providing real-time in the future, so I spent a lot of time picking her brain. Jennifer Proto, a freelance from Long Beach, California, emphasizes the importance of taking notes and imagining yourselves as a reporter. Once you're working, no one is going to hold your hand. You must have the foundation to be quick on your feet and have common sense, she said. There are many questions that students should ask the reporters they work with, and Groves suggests preparing questions ahead of time. Make a list of questions to ask each reporter you intern with, she said. I asked pretty much the same questions to each reporter. One question that I remember asking was, what do I need to do in order to be a great reporter? Each reporter gave something new for me to think on. My favorite answer of them all was to read and notice words on everything. While many reporters are happy to help the next generation of court reporters, not every reporter is thrilled at the prospect of mentoring a student. Don't let that dampen your spirit, though. Some reporters just aren't new reporter friendly. My first interning assignment was with a reporter who had a very negative view of reporting in my area, said Groves. I went home and cried that night. The next time I interned was the complete opposite, and the reporter was wonderful. She took the time to discuss briefs with me and talk about some acronyms she expected to come up on the job. Internships often provide valuable information that students wouldn't otherwise learn in the classroom or in practice. I learned how to handle interrupting a witness with grace, said Groves. I watched a reporter raise her hand and politely ask the witness to stop speaking over the attorney. As a student, I was in awe of how gracefully and confidently she handled it. These experiences are what can help students build confidence. It's never too early to begin to communicate with firms in your area, said Mike Hensley, RPR, a freelancer from Evanston, Illinois. While they may not have much for you to do at lower speeds, you can still begin a relationship that can lead to future opportunities. Be courageous and ask if you can volunteer in the office for a day or a week. The sooner you immerse yourself in the industry, the more time you'll have to build that confidence that will make you a strong, capable reporter in the future. Proto's experience taught her the business side of being a reporter. I remember being impressed with the info on finances and taxes, she said. I have always tried to be diligent with saving receipts, appropriate deductions, and paying quarterlies. Working with a reporter also teaches students about professionalism on the job. My favorite piece of advice was always to sit down in a dressing room when you try on dresses or skirts for work, Grove says. Pretend there's a machine in front of you and make sure the dress or skirt doesn't ride up or the lining shows. Even if your school does not require completion of an internship for graduation, students should consider gaining experience in the field. That's what Hensley did. I had been working full-time while going to school online. Near the time when I began high speeds, I felt that it was important to dedicate as much time as I could to activities related to my future as a court reporter, said Hensley. Being an older student, I didn't have the option to devote all of my time to school. It was required that I had a job to support myself. After reading an article in the JCR about another reporter's experience working in the office of a firm as a student, I realized that would be an extremely beneficial choice for my situation and my goals. Working as a scheduler and production assistant in a firm provided invaluable experience for Hensley. It gave me a huge advantage. Once I started working as a reporter, I already had knowledge of processes that might have taken me at least 1 year to figure out from experience in the field. Working as a production assistant helped me to gain significant knowledge related to transcript formatting and administrative processes, such as submitting job files, billing, and ensuring that a final transcript was absolutely ready for the production office to complete and provide to the client. My experience in the office also gave me a great confidence when speaking to attorneys and legal professionals, since I had already been working with them on a daily basis. Perhaps even more importantly, Hensley had a job waiting for him once he finished school. As a part of my interview, I made it clear that I was a court reporting student. The firm owner expressed an interest in mentoring me while I finished school. Therefore, once I had my license, I already had a job waiting for me as a new reporter with the firm, he said. In fact, I can recall the firm owner checking in with me constantly while I was waiting for my exam results to see if she could start booking me for assignments. Groves also secured her first job from a connection she made during her time interning. I was with a reporter on 2 or 3 depositions, and the other side called in their own reporter for the 3rd depo. I met that second reporter in passing, and the 3 of us, the reporter I was on the job with, the other reporter, and myself, stood and chatted for a bit. It turns out that the second reporter I met that day was a firm owner, and he contacted my school, to get in touch with me and offer me a position with him in a new firm he was opening in my area. Naturally, Groves never would have been given that opportunity if she hadn't seemed professional while interning. First impressions matter. I want to put 5,000 exclamation points behind that, she said. What you wear, how you conduct yourself, and the way you interact with the attorneys and other reporters, it all matters. When you're working, you may run into attorneys you encountered while interning. I have, and they remembered me. I was thankful that I dressed the part and acted professionally when I met them as a student. You truly never know who's watching. All right, now let's see what we have here for some jury charge practice. Ready? Here we go. Members of the jury, it is again my duty to instruct you as to the law applicable to this sentencing phase of the case. The sole question before you is whether Zoksar should be sentenced for his capital offenses to either the death penalty or to life imprisonment without the possibility of release. There is no parole in the federal system. Life without possibility of release means just that. The choice between these very serious alternatives is yours and yours alone to make. If you determine on any particular count that Mr. Czar should be sentenced to death, or that he should be sentenced to life imprisonment without the possibility of release. The court is required to impose whatever sentence you choose as to that count. Remember that you have previously found Mr. Saar guilty of the following capital counts in the indictment: counts 1 through 10 and counts 12 through 18. Those counts are conspiracy to use a weapon of mass destruction resulting in death, use of a weapon of mass destruction resulting in death, conspiracy to bomb a place of public use resulting in death, bombing of a public place, place of public use resulting in death, malicious destruction of property resulting in personal injury and death, and possession and use of a firearm during and in relation to a crime of violence resulting in death. Even though there are a total of 17 capital counts at issue here, you must still approach the sentencing decisions before you separately as to each count. I stress to you the importance of you giving careful and thorough consideration to all of the evidence. As I previously said to you, you must follow the principles of law given to you in these instructions, regardless of any other thought or opinion you may have as to what the law may or should be. The instructions I am giving you now are a complete set of instructions on the law applicable to the sentencing decision as to Mr. Saar during your deliberations. You should thus rely on these instructions. We also prepared a special verdict form that you must complete. The form details the special findings you must make, and it will aid you in properly performing your duties. Now, although Congress in the relevant statutes has left it wholly to you, the jury, to decide Mr. Saar's proper punishment, it has narrowed and channeled your discretion in specific ways by requiring you to consider and weigh any aggravating and mitigating factors that are present in this case. As I previously explained, aggravating and mitigating factors pertain to the circumstances of the crime or the personal traits, character, or background of Mr. Saar, or anything else relevant to the sentencing decision. Aggravating factors are those that would tend to support imposition of the death penalty. By contrast, mitigating factors are those that suggest life in prison without the possibility of release is an appropriate sentence in this case. By requiring you to consider what aggravating factors and mitigating factors are present in this case, the statute requires that you make a unique individualized choice between the death penalty and life in prison without the possibility of release as to the appropriate sentence for the crimes Mr. Saar has been convicted of. The government at all times, and as to each capital count, has the burden of proving its sentencing allegations against the defendant beyond a reasonable doubt. I have previously instructed you about proof beyond a reasonable doubt. Let me remind you of those instructions. The requirement of proof beyond a reasonable doubt is a strict and heavy burden, but it is not an impossible one. It does not require the government to prove a necessary fact or proposition beyond a possible, hypothetical, or speculative doubt. There are probably very few, if any, things in human affairs that can be proved to an absolute certainty. The law does not require that, but the evidence must exclude in your minds any reasonable doubt about the existence of the fact or proposition in question. A reasonable doubt may arise from the evidence produced or from a lack of evidence. If you conclude that the evidence may reasonably permit alternate conclusions with respect to the fact or proposition in question, then the government has not proved that fact or proposition beyond a reasonable doubt. Reasonable doubt exists when, after you've considered, compared, and weighed all the evidence using your reason and your common sense, you cannot say that you have a settled conviction that the fact or proposition is true or correct. Conversely, we say a fact is proved beyond a reasonable doubt if, after careful consideration of all the evidence, you are left with a settled conviction based on the evidence and your reasoning about it that the fact or proposition is correct. While the law does not require proof that overcomes every conceivable or possible doubt, it is not enough for the government to show that the fact or proposition it argues for is probably true. The government's burden is to convince you that there is no reasonable doubt that the fact or proposition it argues for is correct. A defendant never has the burden of disproving the existence of anything which the government must prove beyond a reasonable doubt. The burden is wholly upon the government. The law does not at all require Mr. Saar to produce evidence that a particular aggravating factor does not exist or that death is not the appropriate sentence. However, in this case, as he is entitled to do, Mr. Saar asserts that there are mitigating factors that should lead you to conclude that, all things considered, the death penalty is not the appropriate punishment for his offenses. It is the defendant's burden to establish any mitigating factor by a preponderance of the evidence. Requiring something to be proved by a preponderance of the evidence is a lesser standard of proof than proof beyond a reasonable doubt. To prove something by a preponderance of the evidence is to prove that it is more likely true than not that it is supported by the greater weight of the reliable evidence. If, however, the evidence is equally balanced as to a mitigating factor proposition, the defendant will not have carried the burden of proving the fact or proposition by a preponderance of the evidence. The preponderance of the evidence is not determined by the number of witnesses or the volume of evidence, but by the quality of the relevant evidence. In making the determinations you're required to make at this stage, you must consider the information presented during this penalty phase. You may also consider the evidence previously admitted to the prior liability phase. Let me provide some reminders about evidence and how to think about the evidence that you will remember from the first phase of the trial. First, I'll remind you what is not evidence. The lawyer's summaries of the evidence in their openings when they're telling you what they expect the evidence will be, and now today in their closings when they try to recall it for you, are not part of the evidence. These summaries are an attempt to marshal the evidence for you to try to persuade you to understand it in a way that is consistent with their view of the case. But to the extent your collective appreciation of the evidence differs in any way from the way the lawyers have predicted it or argued it, it is your understanding and your assessment of the evidence that controls. What the lawyers say in their closing statements cannot add or subtract, add to or subtract from the evidence. You have heard the evidence, and it is your judgment on that evidence that matters. I told you at the beginning, and you have seen that I'd be ruling on any questions of the admissibility of evidence as they have arisen. I remind you, there is no significance for your purposes to any of the rulings, either admitting or excluding evidence. Those considerations are wholly separate from the kinds of decisions you'll have to make, and you should give no consideration of significance to any of my evidence rulings. I remind you that evidence that is offered but not admitted is not to be considered by you. Similarly, questions by the attorneys which are not answered by the witness produce no evidence. The indictment is not evidence. Anything you may have read in the press, seen on television, heard on the radio, viewed online, or heard from others outside the courtroom at any point is, of course, not evidence. You have repeatedly assured me that you have abided by my instructions to avoid such information which is not part of the evidence in the case. To the extent you had any prior impressions of the facts of this case from the time before you were called to be jurors, you must completely set aside any such impressions. Again, in the jury selection process, you assured me that you could do that, and frankly I had. If I had not trusted your answers in that respect, you would not be sitting here today. Your focus as you deliberate must be entirely and exclusively on the body of evidence produced in the course of the trial. It would be unfair and a violation of your juror's oath to do otherwise. Let me now address some of the things that are information or evidence for you to evaluate in this stage of the case. You have a very large number of exhibits in the case. You'll have access to all the exhibits that have been admitted in evidence in both phases of the trial, and you may consider those exhibits and give them whatever weight, value, or significance you think they are fairly entitled to receive. The judgment is entirely yours. The digital exhibits, which is a technical matter, can be put on the JERS system, which you used in your prior deliberations, will again be available to you via the monitor in the jury room because of some certain technical limitations. Some other exhibits are available to you by means of a laptop computer, which does not have any other programs or capabilities such as word processing or the internet access. And I remind you, there's no significance regarding which exhibits are on JERS and which are on the laptop. Many exhibits, as in the case, have been physical exhibits or actual items. As before, those are available to you as well. If you would like to view any of the physical exhibits, you shall simply write a note indicating what exhibit or exhibits you would like to view and give it to the court security office, and we will arrange for you to view those exhibits. Remember that sometimes a particular item of evidence is received for a limited purpose rather than the general consideration. For example, some of the exhibits were admitted under a limitation that they could be considered as evidence that a particular event occurred. For example, that somebody said something on a particular occasion, but not as evidence that any affirmative assertion contained in that evidence was accurate or true. Of course, in addition to the exhibits, you have the testimony of the witnesses who appeared here in the courtroom and one via video conference from abroad who answered questions that were put to them. You ought to give the testimony of each witness whatever weight, value, or significance in your judgment it is fairly entitled to receive. With respect to each witness, you should think about the testimony and decide how much value or meaning it ought to have to fair-minded people like yourselves who are looking for the truth. You may find as you think about the evidence from any particular witness that you find credible, reliable, or meaningful just about everything that the witness has said, perhaps just about nothing that the witness has said, and perhaps something in between. Maybe there are some things from a particular witness you find credible and reliable, and other things that from the same witness you're more skeptical of or doubtful about. There is no automatic rule. You don't have to accept any given witness's testimony in total or reject it in total. You should think about the testimony itself and accept what is meaningful and reliable and reject what is not. In deciding the credibility of a witness, you may consider the witness's appearance or demeanor on the witness stand as he or she testified, to the extent any such observations may have any bearing on your assessment of the reliability of that evidence. The appearance or demeanor of other people in the courtroom, including the defendant, the lawyers for each side, spectators in the gallery, or even me, should not be taken by you as evidence for any proposition or conclusion in the case. You may also take into account any partially or bias that a witness might have toward one side or the other. Does the witness have any reason, motive, or interest in the outcome of the case, or anything else that would lead the witness to favor one side or the other in the testimony? A tendency to favor one side or the other might be deliberate and intentional effort to favor one side, or it might be unconscious, arising out of some affiliation or affinity with one side or the other. Again, such tendencies could affect the reliability of the testimony, and you ought to consider whether there has been such an effect with respect to the testimony you've heard. Again, keep in mind in every case there are people who have an association or connection with one side or the other, and it is not automatic, of course, that those people must therefore be distrusted. But potential bias or partiality, conscious or unconscious, by a witness is a factor that you can think about in evaluating the evidence. You have heard testimony from witnesses described generally as experts. All right, we will stop there. And that will conclude our literary and jury charge practice.